What's your minimum specification? Hi everyone, have you ever wondered the difference between an NDA and embargo? Well, here's a mini-series for you. You're watching video 1 of my series NDA versus Embargo. This is video 1, the NDA. Now to start, I have to give some legal qualifiers. So to be clear, throughout this mini-series, I should point out that I am not a lawyer. I have zero legal training. Anything I say in this video should not be construed as legal advice. If you need legal advice, consult a focused expert lawyer who deals with this stuff on a daily basis, not me. At no point do I pretend to be a lawyer, and in no circumstances should the content of any of these videos be used for legal purposes. This is an analysis based on experience and discussions with peers and other tech companies. If this disclaimer puts you off watching the video, I understand. Because I repeat, I am not a lawyer. You're free to watch any other video, but these are just my experiences. So one of the critical things in the technology press, or any press that deals with periodic releases of new commercial equipment or information, is the concept of an embargo or an NDA. These two words, these phrases, are often used interchangeably to mean roughly the same thing. It's an agreement to not publish information or data before a specified disclosure time. However, there are some subtle differences between the two, and how they've been applied to tech companies and the press have changed over the years. Here's my explanation of my experiences as a member of the press over the last decade, as well as some novel interpretations and the new Airbud rules. You're watching video 1, where I'm specifically going to focus on the concept of an NDA. So an NDA and embargo, by and large, are the same thing. They look to create an agreement between two parties in order that both parties agree to not disclose to anyone else information that pertains to the agreement until a specified date, or in certain circumstances in perpetuity or until the end of time. If you sign an NDA, or if you agree to an embargo, you're committing yourself, as well as the company you work for and people underneath that company very often, to that specified date and time. Some of these agreements also include language such that the individual only pertains to the individual and that material should not be disclosed beyond that individual. So I might agree for a briefing specifically for me the person, not me the person as a representative of the company. So there is a distinct difference between NDA, or a non-disclosure agreement, and an embargo, and today I'm going to go over an NDA. So an NDA, or a non-disclosure agreement, is a legal document between two parties that sets out the legal standards and conditions that both parties agree to. Both parties should read and sign the document, and both parties should retain a copy for their records. Most companies use the rough same boilerplate language in their NDAs, the ones I deal with especially, but there will be some complexities and idiosyncrasies depending on the company and the product. Also the location of where the company is based or where I'm based, and I have some examples to go through with you. Now, first up is this non-disclosure agreement from MSI. This is one from 2014, and I'll read through it with you. So, MSI in New Taipei City, Taiwan, and Ian Cuttriss, a media from Anante.com, agree to the following terms and conditions to cover disclosures of the confidential information described as below. The effective date of this agreement is March 12th, 2014. So I'm going way back here, just to make sure we're not covering anything that's more recent. But, you know, it's still the same today as it was back then. For MSI Z97 series motherboard sample review and testing purpose only. Confidential information shall mean trade secret information of all forms and types, whether tangible or intangible, if the owner thereof has taken reasonable measures to keep such information secret. The confidential information is also including any information including naming, photo, specifications, performance, and product description of MSI Z97 series motherboard and Intel Z97 chipset. The confidentiality period, this agreement and recipient's duty to protect confidential information, is 3 years from the effective date. However, after May 11th, 2014, at 1 minute past midnight Pacific time, recipients may release any information including naming, photo, specifications, performance, and product description of MSI Z97 series motherboards and Intel Z97 chipset. So this means that all the confidential information for 3 years, however, any information that's covered, such as naming, photo, specifications, on the embargo date. If I'm told more information than beyond there, then technically I have a duty to keep that information confidential for another 3 years beyond that. Disclosure period. This agreement applies to confidential information described in Article 2 that is disclosed from effective date and 1 year thereafter. So again, if MSI told me confidential information within the year after the disclosure date that wasn't specified specifically in Article 2 here, then I still have to keep that confidential from 3 years from the effective date of the agreement. The effective date is March 12th, 2014, so it's past now. But so number 4, standard of care. Recipients shall protect the disclosed confidential information by using the same degree of care, but no less than a reasonable degree of care, to prevent the unauthorized use, disclosure, dissemination, or publication of the confidential information as the recipient uses to protect its own confidential information of a like nature. So that might mean you can share it within the company that's under this agreement, but no more. Don't share it to friends, don't put it onto a public server. Point 5, marking. Recipients' obligations shall only extend to confidential information that is described in Article 2, and that the information is marked as confidential at the time of disclosure, or is unmarked, for example, orally disclosed, but treated as confidential at the time of the disclosure, and is designated as confidential in a written memorandum sent to recipient's representative within 30 days of disclosure, summarizing the confidential information sufficiently for identification. So, determining what falls under the confidential banner. So if a company shares a slide deck, typically every slide will say, confidential, 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 and that's sufficient for legal purposes. Any materials marked, not marked confidential or orally can be a subject of question. In that circumstance, usually a company will, before the conversation, say, this is still covered by the NDA, or it'll be in the title of an email. It can get very complex if you start arguing that certain discussions weren't held under that confidential banner. And yeah, it can get pretty he said, she said sort of thing, where if it goes down that route. So number 6, exclusions. This agreement imposes no obligation upon recipient with respect to the information that A, was rightfully in recipient's possession before receipt from disclosure, B, is or becomes a matter of public knowledge through no fault of recipient. This one's important because in this NDA, it means that if somebody else releases the information early and it becomes public, I am therefore released from this NDA. But this is a very rare phrase to see in some NDAs. But this is a case of, say Intel makes it public before the NDA date, I'm not held to this NDA. Exclusion C is rightfully received by recipient from a third party without duty of confidentiality. So if somebody else gives me the same information, but without NDA, then I'm released from this one. Exclusions D is disclosed by disclosure to a third party without a duty of confidentiality on the third party. E is independently developed by recipient. So if I discover it, if I can discover it on my own without their information. F is disclosed under operation of law. So if I'm given the information by a legal body. Or G is disclosed by recipient with disclosures prior written approval. So if they decide to nullify the NDA. 7, warranty. No other warranties against infringement. 8, rights. Neither party acquires any intellectual property rights under this agreement except for limited rights. Miscellaneous. 9, neither party has an obligation under the agreement to purchase any product or service from the other party or to offer for sale products using or incorporating confidential information. This is a clarification, so we don't require you to put affiliate links, for example, in anything you publish. Number 10, nothing in this agreement shall be construed as a representation that either party will not be independently pursue similar opportunities, provided that the obligations of this agreement are not breached. 11, this agreement embodies the entire understanding between the parties pertaining to subject matter. Any additions and modifications to this agreement must be made in writing and signed by both parties. Number 12, this agreement does not create any agency or partnership relationship. Each party is responsible for its own expenses. Number 13, and this is a very important one, this agreement shall be governed by and construed in accordance with the laws of Taiwan, Republic of China, and the parties irrevocably submit to the exclusive jurisdiction of Taipei District Court. So this means if there is a legal dispute This document sets out that the legal dispute has to be remedied in Taipei. So while a lot of people that not make much sense, you know, for example, as somebody in the UK, what can a Taiwanese court do to me? If a judgment is lodged against you, it could limit your future access to that country for either you or the company that you represent, or, you know, the inability to travel to the country until you have paid the fine. These sorts of things, because it's not a criminal act, it's just an act against the company, it's more likely to be fined and costs rather than, you know, anything else. So the fact that you're not unable to travel to a country, you know, goes beyond whatever relationship break you have, you know, with knock-on effects on how breaking one NDA may affect how you work with companies in the future. I have a second NDA I want to go through just because it's a little bit different. And this is one from Meizu from 2016. Apologies for the quality. This is an old scanned PDF. Before we actually signed PDFs in Adobe, it's, you know, it used to be print out, sign, scan. Some companies still require that. So this is an agreement between Meizu and Anantech. So, you know, with disclosure and recipient on June 15th, 2016. The parties have or will enter into discussions that may lead to cooperation. In the course of such discussions, it may be necessary for Meizu or any related third party to disclose to the recipient in writing, orally, or by any other means that the parties may elect to use certain information relating to Meizu mobile phones or other Meizu products, in order for the recipient to draft and publicly issue reports on Meizu products, tests and evaluations, which Meizu disclosing such information deems to be confidential. That's a very broad. Basically, any discussion we have with you could be considered confidential, and recipient agrees to use such confidential information solely for the purpose, in this case, of drafting and publicly issuing reports. Parties agree to the parties agree as follows: confidential information shall mean and include tangible or intangible, and whether how stored, compiled, or memorized. Any proprietary information or document controlled or owned by discloser and disclosed to or learned by recipient, including but not limited to Meizu products, testing, formula, patent program, method, strategy, analysis, code, invention, patent application. Confidential information. B, discussion, negotiation, communication agreements between both parties, and C, any other information in relation to Meizu products testing. 1.2. Considering both parties may cooperate case by case from time to time, both parties agree to enter into a relevant confidential disclosure supplement, so CDS, regarding the subject matter for protection of confidential information. Recipient hereby authorizes its employees, the persons who execute the cooperation cases with disclosure, to sign each confidential disclosure supplement on behalf of recipient. So technically that means anybody else within the company that you represent who wants to be under this should also sign it. Protection period and return of information. Unless otherwise specified in clause 4 of this agreement or agree in writing by the parties, recipient's duty to protect confidential information shall be perpetual. So any confidential information that isn't necessarily directly allowed within the release, again, you have to hold on to in perpetuity. The recipient, upon disclosure's written request, will promptly return all confidential information received from the disclosure, together with all copies, and certify in writing that such confidential information and copies thereof have been destroyed. So, at the end of the agreement, Meizu can request that I confirm that I have either sent physical copies back or destroyed all electronic copies. And that would be a legal document that I would sign. Permitted use. The recipient agrees to use the confidential information solely for the purposes specified in this agreement. Recipient will use the same degree of care, but no less than a reasonable degree of care. We've had this kind of thing before with MSI. Exclusions. The agreement imposes no obligation upon the recipient with respect to confidential information which A, the recipient can demonstrate was available in his possession before receipt from the discloser. B, is or becomes publicly available through no fault. Again, this is another one like the MSI one. Both parties shall be responsible for the observance and proper performance of the terms and conditions of this agreement by its employees. In the event that the employee of either party is in breach of any terms of this agreement, the party, as the employer of the employee, shall be responsible for such breach. So you're not personally liable, but the company is liable. Warranty disclaimers, ownership, remedies. In the event of the recipient's breach of terms and conditions hereunder, it shall be liable for any and all damages such incurred by the discloser. Each party acknowledges that damages for improper disclosure of confidential information may be irreparable. Therefore, the discloser shall be entitled to seek equitable relief, including injunction and preliminary injunction, in addition to all other remedies available at law in equity. And as we'll go forward, it will say this has to be in China. Yep, governing law, this agreement is made under and will be construed according to the laws of the People's Republic of China. And then, yeah, similar sort of thing. And signed. So, the whole point of remedy is to provide a direct legal line should one of the parties break the terms of the agreement. So, while not an infringement against the state, the usual remedy is often financial in this case. It can be an infringement against the state if the NDA is related to financial information. If you have information that could technically be considered insider trading, and you release that before the specified date, so say we're talking about financial results disclosures, or you're being briefed that there's a acquisition going on, and you break your NDA or your embargo on that, or particularly these will be NDAs, then you could be liable on a state level, and depending on where you are, that could mean jail time. Again, I am not a lawyer, but an NDA is the highest level of legal document that a tech press person or company is likely to sign. One argument that gets thrown around when discussing NDAs, especially within the tech press, is that by and large they are unenforceable because of the press being in a different location to where the company is, or the company decides to say that the court in which this will be remedied is doesn't have jurisdiction over the person. Also, the language in them may not be technically legal where the press person lives. So for example, imagine a location where there's no such thing as an NDA that doesn't exist in law. Therefore, you can't be held to it. This makes it very difficult for a tech company to actually go to the court. But the company does explain why they choose a specific court in which to remedy if should an NDA ever go to court. So as part of this, you're meant to receive a signed copy of the NDA. So normally the company will send it to you, or in the case of this Meizu one, they actually pre-sign it, and then you sign it, and then you send them that copy, then they send back a signed copy. 99 times out of 100, I don't get a signed copy back, which begs to question whether this is it actually makes the agreement technically legal. Now, it could be argued in court that because the company drafted the NDA and because you signed it, that is legal relations being formed. Though it could also be argued that because we never received a signed copy, then we're both technically not bound to it. I don't know which way a court would decide on that. It probably depends on the location as well. Could be used in defense, could be used as an argument for. And that's... the fact is you're generating legal relations, and that's probably the key element here. So thank you for watching the first video on NDAs. Next video coming up, embargoes. Thank you for watching. If you state all this, again, I'll reiterate, I am not a lawyer, so don't take anything I've said as legal advice, please. I would like to hear your thoughts about this element of the industry perhaps you've never considered before. Or if you are in the press, how you consider. Don't forget to like and subscribe. Like if you liked these series of videos. If you think I'm a complete tool and I have the wrong idea about this, well, you know where to get to me. I'm Twitter @IanCutris, or you can comment below and I'll respond to a few there. So thank you for watching, and what's your minimum specification?